Good afternoon.
Good afternoon.
Good afternoon, everybody.
Good afternoon. Okay, I see Mr. Pratt's message said 12 sharp, so we will begin at 12 sharp. Class is normally from 12 to 3. Yes, the usual time 12 to 3. Normally the students prefer if we just go straight through without any breaks. So I need to know what's your preference. Would you prefer a break? Like around 1:30, or you prefer to just go straight through the class?
Me personally, I prefer to go straight through the class.
Okay, all right.
I agree, straight through.
Straight through, okay, all right, that's fine by me. But in the event you have any Saturday chores to do, you'll have time.
Yes, ma'am.
Okay, all right. Have you gotten the e-copy of the book? He sent the electronic copy?
Yes, I got it.
Yes, ma'am.
All right, so did you read unit 1?
No, ma'am.
Okay.
Whew.
Okay, so before I begin, let me just hear a little bit of what you know about company law before we begin, so I know how to pace it. So, okay, start with you, Olivia. No, not with Olivia, with but how do you pronounce your name?
Makira.
Okay, start with you, Makira.
Okay. I know about the incorporation
The process.
of a regular company and an IBC company.
Okay, all right.
That's basically it. I just know about the incorporation as it refers to, I guess, like the background or the principles of company law. I don't have much knowledge about that.
Okay, all right. That's understood. Let me just make a note as we go. So in the event when we do the process, how to incorporate, if there's anything missing or anything new since the last time we updated the manual, you could surely inform us. Okay?
Yes, ma'am.
All right. Christina.
Hey, okay. So I know the same thing that Makira said, that company law relates to the establishment of companies, whether domestic or IBCs. I also know that, or have an idea that the purpose of company law is to get it to distinguish it from other business structures like sole proprietorship or partnerships or anything like that. So that's what I know. And that's it, outside of the little I read from the, from the Solomon versus Stingham case. I don't really know much.
But don't say it.
Sorry.
You will know a lot by the time you finish this class. Now,
Good.
You'll find with the class, certain chapters are heavy in terms of you're gonna have to refer to legislation, and heavy in terms that there are case law. It's not expected that you will memorize these cases, and it's not expected that you will remember the names, like how you'll know Solomon versus Solomon on the top of your head, because that is the company law case. But a lot of them you won't remember the name, but there's certain things about the stories you may remember or want to apply when you're dealing with a scenario. And so you could just say in a leading case. So don't have that stress on you that you have to remember the name, you have to remember the year, you have to remember the court. No. So just be general information about the case itself. Now, I'll encourage you to read the cases, because once you read the cases and you read the law, you begin to understand more what company law is all about. I see Sandy just joined. Sandy, tell us what you know about company law. Sandy.
So I'm sorry. Good morning, good afternoon, everybody. I was having a little technical issues.
That's okay.
What do I know about company law? I know it's big business in the Bahamas, with a lot of international investors. I know that in terms of the structures, you can have what are called IBCs, or domestic companies, and they have slightly different requirements. That's kind of most of what I know. I should know more, but that's kind of what I know mostly.
Okay, no, that's fine. That's fine. That's why you're here in the class,
Yes.
Yeah. to learn. So no, that's fine. That's fine. All right, and you have your copy of the manual.
Yes, I do. Thank you.
I think they're gonna make the hard copies available so you'll be able to write your notes in your book.
Okay, perfect.
Okay, all right. So,
Hi.
go ahead.
Sam, I didn't see you ask me. I see it have me as the host, but I'm not. I'm also
Oh,
here.
I thought first didn't answer.
Yes, I have basically the same knowledge, just the incorporation part of it, SACs, CACs, IBCs. So, I would say what I lack is the background knowledge of it.
Mhm.
But
Okay,
yes,
understanding why someone would want to incorporate a company, be it
yes,
a or a regular company.
yes.
Yeah, okay, and then what the actual documents mean.
Yes, yeah.
Yeah, you probably have an idea because you do the incorporation.
Yes, but more so in depth.
Okay, so you'll have to learn it in relation to the law.
Yes, ma'am.
Okay, all right, so let's start with unit 1. For most students, I've learned for unit 1, I try not to go too deep into it for the first class. I will go over it, and then when we come to the second class, I go over it again, because it gives you enough time to read it over, to read the cases, look them up, and then we can have a discussion on it, and then we move into the second unit. Because some people find it's like it's a little bit overwhelming because there's a lot of information. So we'll start with what exactly is company law. So company law itself could be divided into 2 areas of activity. And this is not in your notes. So if you would have read what is a company in your notes, I'm just going to give you some background. And we could go over this background again in the next class. But in company law, you have corporate finance and you have corporate governance. And I'm not sure if you've heard of this talk, but a lot of people use that term a lot, corporate governance. Have you heard about it?
Yeah.
I have, yeah.
I've never heard about it.
Yes, quite a bit.
Quite a bit. All right. So corporate finance is really about how the company itself is financed, along with how they raise money. So when you talk about corporate finance, you're talking about whether or not they borrow money, whether or not they have an IPO, seeking investors. That's the corporate financing, going to a bank for a loan and providing its assets as security. The second arm of company law is corporate governance, and which is how the company runs internally, how it is managed, and how it is governed. And you'll see that when we come to the chapter on directors and their duties. So at the most basic level, money is invested in a company. And that could be done by individuals in exchange for shares. Now, this action doesn't mean that they own the company. All it simply is that they own shares in that company. And by them owning shares in the company, it entitles them to attend and vote at the company's general meeting. And that concept is what you have to put in your mind. When a person invests in a company, they own shares in that company, and that shares gives them an entitlement. And that entitlement is to attend meetings and vote. The day-to-day management and the whole idea of a company carrying on its business from an entrepreneurial standpoint is provided by the persons who are employed as the directors of the company. Again, directors do not own the company. They are merely employees. And what they do is they come together and they form the board of directors. So corporate governance focuses on the balancing that needs to be achieved between the company's rights, its duties, and the expectation of the shareholders, the employees, and the creditors, and the directors. All of those bodies make up what we call the stakeholders. So the board of directors possesses its power from where? Where does the board get its power from?
Shareholders?
How? Explain. How you think? Why you say that?
Well, I say that because, like you explained, shareholders are, they carry a level of ownership in the business. So whatever directives, or I guess, however they vote for the company to be directed, or whatever direction the company they want the company to go in, then the directors have to execute on that. I don't want to say directive the third time, but they have to just execute on whatever the shareholders collectively agree in the direction that the shareholders agreed to the company to go in.
I hear what you're saying. Yes. So that's normally what the shareholders will do is at the annual general meeting, they would state, this is what we expect, or this is our strategy, or what we expect your strategy to be. So say if they would saying, I don't know, whatever company their business that they're in, and they see that there are 2 or 3 companies out there that are kind of weak. And then they will ask the board, what's our plan for the next 3 years? Are we going to acquire? Are we going to merge? What are we going to do? Or how are we going to strengthen the company? And the shareholders will look at what the chairman of the board has come up with, and they will say that yes, we think this is a direction we should take the company in. But that doesn't give them the power to do what they want to do. The powers come from the Articles of Association. That's what gives the directors this power. It doesn't matter what the shareholder says. It's whether or not after the shareholder says this is the strategy or this is the direction I think you should take the company in, that directors still have to follow the powers that are given to it in the Articles of Association. And that's why that document is so important. You have to read that document to know what you can and what you cannot do. So if the powers are given to the directors in the articles, the question always arises, like, how do you make them accountable as directors of the company? What mechanism is in place to make them accountable? Anyone has an idea?
The memorandum.
No.
The company
Um,
law?
Perhaps the legislation that governs whatever type, whether it's an IBC or a domestic company.
Yeah,
Guessing.
the company law.
Partly. Part of it is in the Companies Act, and part of it is a part of common law. You know what I mean? Like the common law?
No idea.
All right, so just a little bit of a brief history, so we'll just carve it out. The Bahamas, as a jurisdiction, we were formerly a colony of the UK, and so we now being a part of the Commonwealth of countries, we follow common law, which is precedents from the UK and other Commonwealth jurisdictions. So that's why you'll see when we read a lot of these cases, they're from the UK. But the mechanism that is in place really to make sure the directors are accountable is, like I say, it's in the Companies Act, but there's also a common law duty that a director has. And we'll come to that later down in the chapter. And those duties are what makes a director accountable to the shareholders. Because once a director breaches a duty, the company itself or the shareholders on behalf of the company can seek redress. This means that they can sue the directors. Corporate finance on the opposite side, that covers, like I said earlier, the raising of money. And there are two ways in which a company can raise money: equity finance or debt financing. So equity is where a company issues shares for the purpose of increasing its capital. And of course, the shares have rights attached to it. A debt finance is where a company is going out to try to secure loans. And for a bank, if you're getting a bank loan, these are normally secured over the assets of the company. So that in the event of a default, the bank could seize the company's property to satisfy the debt. And of course, creditors are always protected under the Companies Winding Up Act. So let's go now to your notes. A company implies an association of a number of people, and they normally come together for a common objective. So say right now, the three of you decided that you want to form a company. But of course, one can't be wanting to form a company to open up a veterinarian service, and the other one wants to do a bakery. The other one wants to do sewing. It has to be a common objective for that company. And people form it for protection. And another reason people form it is for economic purposes. So there are three types of companies: those that are formed for profit, for profit itself. Then there's those that are formed for not-for-profit, such as the non-profit organizations, or for social purposes. Those that are formed to enable a single proprietor or group of partners to carry on a business. Or some companies are formed to enable the investing public to share in the profits without taking part in its management. And that would have been the last IPO when they were looking at the downtown project, where you could have invested at a minimum of what it was, 500 or 1,000. into the downtown project. So you would become an investor, but you're not a part of management. So to form a registered company, the requirements for registration must be met and the documents prepared as required by the legislation. So once the formalities are correctly completed together with the fees, the Register of Companies issue a certificate of incorporation. So the company itself does not become a separate legal entity until you have that certificate of incorporation in hand. Every company, like I said, has two organs, the directors and the shareholders. The shareholders are the owners of the company in terms of owning shares, which gives them a right. And their forum is the annual general meeting. The directors are the ones that provide the management of the company, and their forum is the board meetings. Now, board meetings can be quarterly, board meetings can be monthly. It depends on what is happening in the company. So the company itself, once you have that certificate of incorporation, it is a legal entity, distinct and separate from its shareholders and principals. In law, it has its own existence. It has its rights and its duties, and they are separate and distinct from the shareholders or members of the company. As a separate entity, a company is not an agent of its shareholders and principals. But you will find out later down that there are some exceptions to that. So a company is considered an artificial legal entity and not a natural person. And this was held in the case of DPP versus Zerazinski. And that's where a company brought a prosecution through the Director of Public Prosecutions under the protection from harassment. And the court ruled that the prosecution failed because the company could not be regarded as a person. As the act, if you're talking about harassment, the act itself envisioned it being done by a human being. So, yes, everybody wants to form a company, whether it's under the Companies Act or whether it's under the International Business Act. But before a person decides whether they want to form a company or not, they look at other options. And the other options is you can conduct your business as a sole proprietor, or you can form a partnership. Now, a sole proprietor or a partnership, they are not separate legal entities. A sole proprietor has all of the control of the company. No one tells them what to do. They are also totally responsible for that business, and all of the liability rests with them. He doesn't have to explain to anybody what he's doing or why he's doing what he's doing or what his plans are. And he's not required to register any financials, file any financials, or provide any form of documentation to the registrar. That's the sole proprietorship. So it has its advantages and it has disadvantages. A partnership is a non-corporate entity, and a partnership is dissolved when a partner retires or that person dies or becomes bankrupt. The partnership will normally continue with the remaining partners. but that is always subject to what was arranged in the partnership agreement. The retiring partner is entitled to be paid his share in the firm. If the partner dies, the executor of that deceased partner's estate and the trustee of the bankrupt partner are also entitled to payment of their relevant share. This results in a return of capital in the partnership. It also can affect the business itself. Because what it does is, if you're returning capital, then you're going to be reducing the amount of funds that the partnership has to do business with. So in some instances, what you can do is you can arrange for a deferred payment. So that means that you pay them a certain amount over time. The legal and financial liabilities of the partnership extend beyond the partnership to the individual partners. And so that means that once it extends to the individual partners, it means that their personal assets are also exposed to creditors. However, his business affairs are private, just like in a sole proprietorship, and there's no obligation to register financials or corporate information at the public registry. So again, the advantages is having that privacy. So the main advantage of incorporating a company versus a sole proprietorship or a partnership is that the company survives the death of the shareholders, the principals, and ultimate beneficial ownership. The legal and financial liabilities related to a sole proprietorship extend beyond directly to the owner and his personal assets, and is not limited to the business enterprise. The legal liabilities of a sole proprietorship are unlimited, and creditors or anyone who wishes to sue can claim and enforce a judgment relating to that sole proprietorship against any of his personal assets. And this is one of the major disadvantages and risk of a sole proprietorship. For a partnership, creditors may sue the partners individually to satisfy their obligation. The partners are liable for the actions of the other partners, where such actions were done on behalf of the partnerships or in the partnership's name, subject to certain exceptions. The liability of a company is limited, and shareholders' losses with regard to the company's actions cannot exceed the amount of money that they invested in the company. So a retiring shareholder has to find a buyer for his shares. A trustee in bankruptcy or a trustee must also find a buyer for the shares. Now, a company may purchase its own shares. A company may also issue more shares. It can add directors and shareholders. It can expand or downsize. It can subject to the memorandum and articles of association. And they could do that without changing its legal existence or the structure. So normally when you read, even in the shareholders agreement, which we'll cover later down, you see sometimes the shareholders stipulate how many directors the company should have. And then you'll see in the, it will say what is the minimum amount of directors that the company should have. So a member of a company is only liable to contribute to payment of a company's debts to a limited extent. Like I said earlier, is only up to the amount that you invested. So while a shareholder is liable to contribute to the payment of a company's debts, he's not liable to pay them himself. So a creditor can't sue nor compel him to pay such part of the debt that is equal to the amount of the unpaid capital in respect of his shares. So a company itself can be a corporation sole or aggregate. A corporation sole refers to where the company consists of only one member at a time holding a perpetual office. An example of this is a public trustee. A public trustee is the sole member of a corporation. And therefore, the office of the public trustee is personified as a corporation sole. And the trust property is vested in the corporation and is not affected when the human person changes. A corporation aggregate consists of a number of persons who in law form a single person, a registered company. A registered company is an entity separate from its members. And a registered company can be incorporated either under the IBC Act as amended or the Companies Act as amended. Upon the reservation of a company name and the statutory filing of the memo and articles of association, and of course, then the issuance of the certificate of incorporation by the registrar. Any questions or comments? No?
I have a question, Ms. Archer. Can you elaborate a bit on the title of a public trustee? As it relates to a corporation, is it, and I'm trying to follow the notes, are they considered a public trustee if it's a public corporation? Or
No.
even,
No. The public trustee itself
Mhm.
is an act, a piece of legislation.
Okay,
Yeah, so it's a legislation. And so under that legislation is called a corporation sole because under the act, it's a civil servant, a government official who becomes the trustee. And that who that civil servant is the only person under that act acting at that time.
okay, perfect. Okay, I got it. Thank you.
Okay, I have a question. Okay, so let's say in the case where a sole proprietor, a single person wants
Mhm.
to incorporate a company, so they
Right.
can't do it because
Yes.
does a company require more than one person?
No.
I don't know if I asked.
Yeah. No, you're
So
asking.
me,
You're
so
asking.
me as a single person can go ahead and incorporate a company, and then I could have 100% shares, and I could be the director, I could be the president, I could be the secretary, I could be able to sign off on all the documents.
Mm-hmm. That's what happens
So
every
what?
day.
So what if they call it articles. The article says that there must be no more than 2 directors. So
That's under the
in
Companies
that
Act.
case, say it again.
That's under the Companies Act.
That there must be no more than 2 directors, right?
Mm-hmm. So under
So
the
I'm trying to figure.
but if you incorporate under the IBC Act, the requirements are different.
Uh-huh. So me as an individual, I could incorporate an IBC.
Mm-hmm.
Okay.
Yes.
What are the stipulations for IBC? Because I know that under the Companies Act, it requires 2 persons minimum. But under the IBC, could you explain IBC? Because my brain about to like explode.
I know it's going to, that's why I warned you all from the beginning. No, we're gonna come to the requirements between the two later. But like I'll explain IBC to you. So an IBC, all right, let me do the next way. Try to make it simpler for you. If you want to go into business and you don't want all of your assets exposed to creditors, so you want that protection, number one. Or you want to say that I have this business, or in my mind, I have this business. If I go ahead and I have it as a sole proprietorship, in the event something happens to me, the business is gone. So I'm looking for something that can continue to my children or my spouse, whatever, my family. You then decide that you want to incorporate a company. Now, in the Bahamas, you have choices. You can either incorporate the company under the Companies Act, or you can incorporate under the IBC Act, the International Business Act. The International Business Act was actually drafted to attract foreign investors, those who wish to do business internationally without using their name. So it gives the person who incorporates the company anonymity. So your name is never seen. The certificate of incorporation says ALP, Arawak Limited. They have all kinds of names. And that's the name that you transact business in. But the requirement from the Bahamas says also, if you want to incorporate an IBC to do business, you must have the registered office and agent here in the Bahamas. So you can do your business, but just that corporate service for your company remains here in the Bahamas. But it carries the same features in terms of perpetual succession, limited liability.
So as a domestic company, you don't necessarily need to have a registered company or agent filing your stuff every year.
Oh, no, you still need one.
Okay.
Any more questions? Because that's required by law. You'll see when we go through the act. Any more questions? When your head begins to hurt and there's too much, you need to tell me.
I like the way you put that.
No, because
Thank you for saying that.
yeah, no, I've had it before, and I don't like to push it too much, because then when it comes to the second class, it's two things: either you're not going to return, or you're not going to understand going forward. And then the pressure is on when we start to say midterm and then final exam, and you just can't do it. So I prefer for you to tell me it's enough, than to try to put too much on your brain at one time. Fair?
Yes, more than fair. Thank you.
Right.
That's fine.
All right. So once a company is incorporated, it becomes a separate legal entity. And that's a concept, like I said earlier, you have to understand. It is separate from its members or shareholders. And it is not an agent of the shareholders. So it depends on what you do later on in life in terms of dealing with companies. You will see sometimes where persons would actually conduct business as if the company is an agent of the shareholders, bypassing the board. Of course, in an IBC, you will notice that the shareholder the director, and the officer are all one and the same. But that can be done because that was the purpose of creating an IBC. So with that separate legal personality from its members, the company itself enjoys different rights, the duties and the liabilities of its members. So picture in your mind, draw like a building in your mind. On the left-hand side, you see 3 or 4 persons. Then you have that building there. Those 3 persons, they have shares in that building. That building itself has its own rights and duties. It has its own responsibilities. And everything that's connected with that company is based on the principles set out in Solomon versus Solomon. And in Solomon versus Solomon, Mr. Solomon converted his sole proprietorship into a company. And he, along with his wife and his daughter and his 4 sons, they signed they were the subscribers to the Memorandum of Association, each taking 1 share. They then appointed Mr. Solomon and his 2 sons as the director. So Mr. Solomon was paid £39,000 for the business. As part of the consideration for the sale of the business, Mr. Solomon received fully paid up shares and debentures to the value of £10,000, which he subsequently assigned to another party. You have any questions there?
Can you say it again, the last part, please?
Okay. So he was a sole proprietorship. He had his own little business. And then he wanted to incorporate a company. Of course, again, to limit liability and for perpetual succession. So the subscribers to the company were his wife, his daughter, and his sons, each taking 1 share. So, you know, if he's moving from a sole proprietorship to a company, of course, the company then, once incorporated, has to pay him. So the company paid him £39,000 for his business as part of the consideration. Now, when I say consideration, in company law, in order to effect a contract, you must have an offer with acceptance and consideration. Consideration is money. If not money, then it's an act that's equivalent to money. So obviously he would have come to an agreement between his sole proprietorship business and the company under how much they will pay. So they agreed to pay him £39,000. And as a part of that, he received his fully paid up shares, and he also got a debenture. So a debenture is like a long-term debt. It's not secured by any collateral. So it's an agreement between him and the company. But the value of that debenture was £10,000. And with a debenture, which is like a note, he was able to assign that to another party. So once he formed the company, as a going concern, the company failed. And became insolvent, and a liquidator was appointed. And the liquidator wanted to hold Mr. Solomon liable for the debts of the company. And his argument, the liquidator, was that the whole transaction by Mr. Solomon moving from a sole proprietorship to a company was fraud. And he also wanted to say that the company was Mr. Solomon's agent and that he needed to indemnify the company and all the creditors for the debts incurred by the company. So the lower courts agreed with the liquidator, and Mr. Solomon appealed that decision. And he took it all the way to the House of Lords. And the House of Lords concluded that the transactions were not contrary to the act. They say the company had been duly formed and registered and was not a mere agent of, nor was it a trustee for Mr. Solomon. The judge said that when the memorandum is duly signed and registered, a body corporate is formed, and it cannot lose that status by issuing the bulk of its shares to one person. So you see what the argument was. The liquidator was saying that because the bulk of the shares of the company were issued to Mr. Solomon, then it's fraudulent. One, and also because the bulk of the shares were issued to Mr. Solomon with a debenture, which is a long-term loan, he's saying that Mr. Solomon was acting as an agent on behalf of the company. So Lord McNaughton said further, he said, the company is at law different person altogether from the subscribers to the memorandum. And though it may be that after incorporation, the business is precisely the same as it was before, because remember, it really hasn't changed, it's the same. When he had a sole proprietorship, who was in charge? Mr. Solomon. When he incorporated the company, who was in charge? Mr. Solomon.
Yeah.
When he was the sole proprietorship, who owned the business? Mr. Solomon. When he incorporated the company, who owned the business? Mr. Solomon. Okay. So he said, and though it may be that after incorporation, the business is precisely the same as it was before, and the same persons are managers, and the same hands receive the profits, the company is not in law the agent of the subscribers or trustee for them, nor are the subscribers as members liable in any shape or form, except to the extent and in the manner provided by the act. So the court said there was no fraud upon the creditors or the shareholders. The creditors of the old business had been paid off. The unsecured creditors were creditors of the new company and should have known the risks that they were undertaking if the company went into liquidation with insufficient funds. And that's why whenever you're doing business with a company, it's always sound to have the accounting department. If you don't have an accounting department or you're doing accounting yourself, to always check that company's financial statements, because then you enter into business at your own risk. Members with fully paid shares could not be required to pay more. Any profit which Mr. Solomon might have made as a promoter selling his business to the company were fully disclosed and approved by the shareholders, his family. This Solomon principle affirmed that a company is not per se the agent of its shareholders, even if control is concentrated in only one shareholder. The mere fact that a person owns all the shares in a company does not make the business carried on by that company his business. Once the company is legally incorporated, the company is treated like any other independent person with rights and liabilities of its own. Any comments? No?
So I have a question,
Right.
right? So let's say in a case where I have a company and my company has, let's say I have $1,000, right?
Mhm.
Like my company made $1,000 and me as an individual, I have $1,000. And let's say if something was to happen against my company and I had to pay, I guess I had to pay someone, right? That money that I pay, that comes from my company and not me as an individual, right? So let's say I had to pay this person like maybe like $2,000, but
Mhm.
my company only has $1,000. So if they was to sue my company and my company has $1,000, like where am I supposed to get that next $1,000 from? Does that come from what do I have to do? Do I have to sell like, I don't know, maybe my assets or whatever in order
In,
to pay that person off?
in the,
Or
co-
go
that's
ahead.
that's a debt of the company.
Okay, so it has nothing to do with me personally. It has nothing to do with my funds or anything.
No, your
Okay.
liability, your liability is only to the extent of what you invested in the company. That's it.
All right.
So now you see why people form companies, right?
Yes, ma'am.
So, okay, so if you're transitioning from a sole proprietorship to a limited company, there has to be an exchange based on what you're saying. There has to be some kind of financial exchange
Yeah.
in which the company, the newly formed company, whether it's, just transitional or whatever, has to pay the sole proprietor for the business.
Mm-hmm. And they do that via shares, maybe via some cash, some long-term deferred payment, like a debenture.
Like a debenture. So in the case of Solomon, or whatever, he pretty much put the new company in debt by having to pay him for the business.
Yeah, well, you call it in there.
Or, well, okay, or he had to pay nonetheless a large sum. The company had to pay a large sum. But so the monies that the company itself had, that would have been from the shareholders paying for shares or buying shares.
Yes, and the shareholders was him.
Oh, wow. That is okay.
It's one and the same person.
But he would have had to use the former company's revenue to pay.
What former company?
Wait, hold on. But he would have had to use the revenue that was made from the sole proprietorship business for the company to buy the business from him.
No,
Can you explain that? Like how that would have worked?
you mixing it up. Okay,
Yeah.
okay, let's see. Let's say you had a sole proprietorship and you were selling ladies' clothes.
Right,
So you decided that you want to form a company. You don't want all of that exposure to liability from creditors.
right,
So you decide you want to convert that sole proprietorship into a company. Now, you go ahead and you file your memo and arts. You would have reserved your name, and you now have a certificate of incorporation. So you have a company. It's just a shell.
right, yeah,
The subscribers were you, your sisters, and your brothers. So you all own the shares. Let's say you started up at a capital of $5,000.
right,
You want to continue on that you want to transfer that clothing business into this company.
right,
That assets of that company now need to transfer to this. Assets of that sole proprietorship has to transfer into this company.
right,
So, right. So you now have to determine how much is your sole proprietorship worth,
mm-hmm,
because all your inventory is going to move over.
you're right,
Any creditors that the sole proprietor owed has to be paid off.
mm-hmm. And it
So
would
let-
be the company's responsibility to pay those off,
No,
or the sole proprietor has to pay that off before the business is transferred.
yes, you're not gonna take on the assets and all of the liabilities.
Okay,
So let's just say you agreed between you and your family members, because all of y'all were together in the sole proprietorship. Let's say the manager, someone else was running the store, whatever it is, whatever arrangement you have. And then you decided, guess what? My business itself, for selling the business, I want to be paid. First thing you could do as a business person,
right,
selling the business and promoting the business and moving into the company, I want to be paid X number of dollars. And then you could say, looking at the assets of my company, the valuation of my company, that's going to cost about $39,000.
okay,
And I have some goods that are on its way coming in, and the value of those is, I don't know, say $25,000.
mhm,
But you don't have to pay for those right now, because we haven't started running the company yet.
right,
So what we'll do is we'll sign a note, and you can pay me $5,000 every 6 months until that note is depleted.
oh, okay,
You
so,
see?
oh, okay,
So you form the company and you move the assets from the sole proprietorship into the company.
right. How does that look, even like when it comes to, so then, because considering this is the same person, right? Essentially, a new account would need to be created for the company itself in terms of bank account.
Yes.
So you wouldn't necessarily be changing the first account into the new account. You just have to create a whole new account.
Whole new account. But don't forget, now company is a separate legal entity. That
Right.
is- will not be connected to you at all.
Wow. And as the company is run, it's responsible for paying or transferring payment to you for the purchase of the business.
Yes. Whatever agreement that you made.
Okay, okay, I got that. All right,
See how wonderful it is?
yes.
So in the case of Makura versus Northern Assurance, that's another case. Now just remember,
Ms.
Follow-
Archer, before you move on to the case, just, it's very quick.
Go ahead.
I keep seeing this fully paid up shares. What does that mean?
Okay, so say if you're issuing shares at the price of $1 each,
Mhm.
and you as a subscriber, you want to invest 10,000, you want to buy 10,000 shares at $1 each. So fully paid up shares means that you paid your $10,000.
Okay.
So some people, when they subscribe or they invest, they'll say 10,000 shares, but they're only issuing 5,000 shares, and out of those 5,000 shares, some investors are not paying all of their monies upfront.
I see. Okay. Okay.
That's another thing I had a question about. I'm so glad that I think it was Sandy asked that. So these new investors say that the only revenue that you would have been getting is from the business that you would have been running.
Mm-hmm.
So you purchased the shares yourself from the finances that you would have been earning from the other business,
Mm-hmm.
and those still remain separate essentially.
Mm-hmm.
But you are required though, because I know that the standard is normally it's be like $1 par value with each share. Well,
Yes.
in some cases.
Mm.
So you pay that. If you get 500 shares, you owe the company $500, and that's essentially then how the company gets its funding.
Yes, that's the capital.
And that's on the corporate finance side.
Yes.
Okay, got it.
Mm-hmm.
Wait, I have another question.
Mm-hmm. Go
While
ahead.
on the same topic. So when you get an incorporated business, say you're trying to get a loan investment from the bank, and you want to get
Not loan investment, a loan.
a loan, right? You're right. A loan from the bank.
Mm-hmm.
And the business technically only has 5,000 shares if it's a domestic with $1 par value, but you need, say, $50,000 of a loan investment.
Mm-hmm.
Are they then going to be giving you that loan investment on the projected value?
No. You will have
Okay.
the personal assets.
They'll be doing that based off of what?
You will have to pledge your personal assets.
Ooh, okay. Even though it's a company.
Mm-hmm.
Oh, okay.
Because the company doesn't have sufficient assets.
Yeah.
So what you may have to do is you may have to get the loan in your personal name because you're using your personal assets, and then draw up a contract between you and the company.
But you would still be held liable though for,
Yes, that loan will be your loan.
so that's normally then what banks do, even though they require for some people to be incorporated before they consider giving you a loan.
Say that again.
So that's normally the practice that banks or financial institutions do when they are considering your company to give you a loan.
It depends. We're gonna do a chapter called promotion
Okay.
before a company is incorporated, and there are documents that can be drafted where the company becomes liable for the debt.
Okay. All right.
No, they're good questions. You all have good questions. Your minds are ticking. Yeah. So Makora is another case. So Makora was the owner of a timber estate in county, and he formed an estate company and sold the timber to it for 42,000 pounds. The purchase money was paid by the issue to Makora and his nominees of 42,000 fully paid shares of $1 each. So no other shares were issued. He also financed the company and was an unsecured creditor for 19,000 pounds. His other debts being insignificant. Makora effected an insurance policy on the timber in his own name and not in that of the company or as an agent for the company. On the 23rd of February, most of the timber was destroyed by fire. Makora claimed under his policies but he was held not to have an insurable interest. He could only be insuring either as a creditor or as a shareholder of the company. And neither a simple creditor nor shareholder has an insurable interest in a particular asset which the company holds, since the company is an independent entity. Do you understand that?
I think I do.
Okay. Christina? Sandy?
Can you repeat the last part?
Yeah,
I missed
yes,
it.
I'm following.
Okay. What, that he could only be insuring either as a creditor or a shareholder,
Yes.
but neither a simple creditor nor a shareholder has an insurable interest in a particular asset which the company holds. So
Okay.
under insurance law, you have to have an insurable interest
Right.
to insure an item. And he didn't have an insurable interest because he had already sold the assets to the company and he got shares.
Okay, I got that.
Yeah. So he couldn't do that one. So in the case of Lee versus Lee Air Farming, Mrs. Lee's husband formed the company, Lee's Air Farming, which carried on the business of crop spraying from the air. Mr. Lee was killed while piloting an aircraft during the course of topsoil dressing, and Mrs. Lee claimed compensation from the company as the employer of her husband under the New Zealand Workers' Compensation Act. Since Mr. Lee owned 2,999 of the company's shares, valued at £1 each, and since he was also the governing director, the question arose as to whether the relationship of employer and employee could exist between the company and him. One of the first acts as governing director had been to appoint himself the only pilot of the company at salary arranged by himself. The substantial question was whether Mr. Lee was a worker within the meaning of the Workers' Compensation Act. Was he a person who had entered into and worked under a contract of service with an employer? The deceased was paid wages. The company kept a wages book in which these were recorded. The work that was being done at the request of farmers whose contractual rights and obligations were with the company alone. It cannot be suggested that when engaged in the activities, the deceased was discharging his duties as governing director. Their lordships found it impossible to resist the conclusion that the active aerial operations were performed because the deceased was in some contractual relationship with the company. That relationship came about because the deceased, as one legal person, was willing to work for and to make a contract with the company, which was another legal person, legal entity. A contractual relationship could only exist on the basis that there was a consensus between two contracting parties. The court held that Mrs. Lee was entitled to compensation because her husband was employed by the company in the sense required by the act, and the decision in Solomon versus Solomon was applied. Any questions?
No, I got that.
Got that?
Yes, that one's straightforward.
I want to say,
Yeah.
so even though it was his company, even though he was the majority shareholder, even though he was the director, he was also an employee. And by him recording his wages in the book, it proved that he was an employee. So there are two exceptions in the Solomon principle that a company is entitled to distinct. It was an entity that's distinct from and not an agent of a shareholder. And those exceptions is when there is an agency relationship between the company and the shareholders based on facts, or where the corporate structure conceals the true facts. That is, it is a mere facade. And in this case, the court will disregard the separate legal entity and reach the shareholders behind, or what we call pierce the corporate veil. Now, I don't know if you had a chance to check your email. I would have sent you a link to a document. Anybody saw that?
Yes, ma'am.
Okay.
Yeah.
I'm gonna give you a couple minutes to
Yes,
read,
Mhm.
and then after class, you can read it some more before the next class. So open it up. It's not that long. Let me pull mine out. This is an interesting case because it involves a female.
Just to make sure we're reading the Petroda,
Press versus Petrodol.
the 45-page document.
You're gonna finish read it tonight. Don't worry. You're not gonna read the whole thing.
Oh, okay.
Just reading the first 2 pages to get an idea of who is bringing it up or what
Okay.
the issue is really about.
Okay.
You got a gist of who the parties are?
Husband and wife?
Yes, husband and wife. A divorce,
Yes.
but he had lots of companies. And he put his assets in the companies. Okay, so let me preface this for you so you have an idea of where we're headed in company law. So in company law, you already know it is established that once a company is incorporated, it's a separate legal entity, separate from its members. But there are times when a court will go behind that entity. So even though the principle settled in Solomon versus Solomon led to the use of the phrase, what they call the veil of incorporation, they said that really hangs between the company and its members and acts like a screen. So again, put in your mind a house or a company and a veil behind it, and then the members are behind that veil. And that veil could only be lifted by the judiciary or by statute. So the judiciary lifting that veil during the past years has been controversial. The argument has been that sometimes the court lifted the veil when they shouldn't have. The reasons they gave were not the reason. This case now of Press versus Petrodel is the most recent case where the judge goes through all of the cases where the veil has been lifted, giving his reasons why they should not have been lifted. And in this case, the judge does something different from other judges had done in the past. So like I say, the veil can be lifted by the judiciary or by statute. So under the judiciary, it is often said that it's difficult or to be precise about the circumstances in which a judge will lift that corporate veil. Remember, lifting the corporate veil means going behind the company to find out who the actual members are or shareholders are. So in the case of Conway versus Ratui, Lord Justice Ould, he said, the readiness of the courts, regardless of the precise issue involved, to draw back the corporate veil to do justice when common sense and reality demand it. So what is evident is that on occasions, the Solomon decision has caused problems. And the courts have had to remove the veil of incorporation to enable them to see what's the commercial reality behind the corporate personality. And that's what they attempted to do in Press versus Petrodel. So in other words, the court will lift the veil of incorporation in cases where the incorporator is trying to avoid an obligation or achieve an unfair advantage, or where there is an abuse of the corporate form. But there are some occasions where the court will remove the veil. But the concern always from the judiciary side is they're trying not trying, they want to protect the corporate form. And the courts will only intervene when necessary due to the considerable reluctance to move away from the Solomon principle. Remember that Solomon principle is whole sacrosanct. No one wants to go behind that. A company is a separate legal entity, and that's the principle that the judiciary stands behind. So in the case of Adam versus Kate Industries, in that case, the decision is useful because it discusses the three main categories when the court will lift the corporate veil. One, when it's a single economic unit. Two, when there's been a fraud or sham. And three, where there is an agency relationship. So if we go to Pest versus Petrodel, the divorcing couple, Mr. and Mrs. Press, were wealthy. They own a substantial matrimonial home in the UK and a second home in Nevis. Mrs. Press contended that her husband's wealth vastly exceeded this and argued that properties held by several companies, of which Mr. Press wholly owned and controlled, were in reality owned by him. So even though the matrimonial home itself was also owned by one of the companies, it was established in the lower court, and this was held on trust for Mrs. Press. And it didn't form a part of the appeal in the Supreme Court. So the case was originally heard in the family court and as an application for ancillary relief by the wife in the case of divorcing spouses. And it was held that although there was no general principle by which the corporate veil could be pierced, this was possible under the Matrimonial Causes Act. Three of the companies of which Mr. Press was the majority shareholder appealed to the Court of Appeal, in which the majority criticized not only the law justice dicta, but the general practice of the family courts to use the Matrimonial Causes Act to pierce the corporate veil, and asserted that in the absence of abuse of the Solomon principle, the law did not permit this. So what was the issue? The issue was how to ensure that, particularly in cases of divorcing spouses and in single-man companies, company law could not be used as a tool to conceal assets or to avoid liability in relation to those assets, while maintaining the integrity of the Solomon principle. The Supreme Court unanimously overturned the Court of Appeal's decision, and the leading judgment was given by Lord Sumpton, who observed that the law relating to the circumstances in which it would be permissible for the courts to pierce the corporate veil was characterized by inadequate reasoning. Despite this confusion of the law, Lord Sumption asserted that the position established in Adams versus Cape is that the doctrine of veil piercing required some dishonesty on the part of the company member and was not simply a device that could be employed to ensure justice in a particular sense. His lordship went on to observe that this principle had been affirmed, Trustor AB versus Smallbone, in which it also established that the dishonesty must involve company law being used as a sham or facade to disguise the ownership of property. So you're gonna have to read that case for next class so we can discuss it. So following the decision in Press, the courts have continued to approach veil piercing cautiously, and they sought to limit the use of piercing the corporate veil, because if they kept piercing the corporate veil, what's going to happen? The whole principle or Solomon versus Solomon would be eroded. So in every case in which the case of piercing the corporate veil arises, the court has to balance the need to uphold the core principle of corporate personality with the need to avoid the principle from being abused. It is still useful to try to consider the case law in the area under the traditional categories. So under traditional categories, there are quite a few subheadings. One is abuse of the corporate form. One of the fundamental areas where the courts appear willing to lift the corporate veil is where the corporate form is being used as a facade, a sham, or as a mask. The cases for that is Guilford Motor versus Horn, Jones versus Lipman, Wallensteiner versus Moore, and Hellenic and General Trust. The second is where there's a group of companies, human and commercial reality of the group. And the courts have on occasion lifted the veil of incorporation to allow a group of companies to be regarded as one. And the cases for that is DHN Food and Tower Hamlets and Rattouille and Regent House. The third, where the corporate veil has been lifted, is a group of companies with the concept of agency. And the concept of agency has sometimes been used by the courts under which a subsidiary is regarded as an agent of the holding company. The effect is that the transaction entered into by a subsidiary are regarded as those of the holding company, for which the holding company is liable. And the case for that is Firestone Tire versus Rubber. No, Firestone Tire and Rubber versus Llewellyn. The fourth is illegality, and the courts have been prepared to draw aside the veil of incorporation in order to establish that a company was owned by a national of an enemy country. And so that meant that you don't do business with that company. The fifth could be personal relationship company, a breakdown in the management of the company or the complete exclusion of a member director from participation in management have been redressed by winding up the company on the just and equitable ground by regarding the company as in fact, if not in form, a partnership. And the case for that is Daimler versus Continental Tire and Rubber. It should be noted that concepts such as fairness and justice do not play a leading role in the court's consideration of whether or not the corporate veil should be lifted. The prevailing attitude of the judiciary is that those individuals who adopt the corporate form should expect to take the highs with the low. So normally for homework, I like to assign cases. Go to the end of Unit 1. You see that lovely list of 53 cases? Yes?
Yes.
Okay.
Yep, seen it.
So seen it. Wonderful. So let's do some
It ain't lovely, but I see it.
It is.
one. Who won
It's lovely, but not in a lovely way, right?
yesterday?
No.
Who wants to do
And long.
who wants to do Adams versus Cake?
This is for homework?
Yes.
And the
Okay.
goal is to read them and do what with it?
Summary.
Ooh,
I'll take Adams versus Kate.
Okay,
That's number
Sandra,
5, number 5.
yeah. Let's see. DHN Food Distributors. Oh, everybody quiet. DHN Food, that's number 10.
I can do number 10,
Who that was?
Olivia.
Someone to do Daimler, number 9.
I could do Daimler.
Christina,
Yeah.
and need someone to do Jones versus Lipman.
I'll do that one.
Okay. Okay, number 18. Everybody has one A. Okay. Feel like doing 2?
No,
No.
not at all.
Okay. And of course, everybody will read press for discussion.
Request for discussion.
Yeah.
Quick question, speaking of lovely list, do you happen to have a glossary of commonly used terms and phrases in company law? Like, let's say I had this question about fully paid up shares and subscribers and all that. Do we have something, a list like that compiled anywhere? For the purposes of this class, I mean.
No. I mean, normally the definitions of what's in the Companies Act itself. I don't have anything. Let me see if any of my texts have it. A gloss. I don't recall. I've never looked for one. So this give me
Okay.
And another question, where can we find these cases? Are they just like on Google?
Yeah, they're online.
Okay.
You'll even find the summaries online.
Oh,
And when we write the summary, is it in a particular format, APA?
No. On
Okay.
online, you will see the summaries. So when you present your summary, you should have already read the full case. So online, you'll see the full case and you will see the summary.
Okay, so what are we to do? Sorry.
Yeah. Present it to everyone. You're going to share it. So you're going to say why the court lifted the veil. You're going to give everybody a summary of what the issue was and then the decision held by the court.
Okay.
I think I may have seen one somewhere. No, this is just cases. I'm looking for her thing. Don't worry, we still have another part of the chapter to finish. That's not it. Let me
of
just-
this chapter, of this.
Yeah, one more part. Don't die yet.
Well, I don't want to take any more time. I can probably research it independently. And if I come across it, I'll share what we have for next class.
Okay, no. Now I'm looking for your glossary, no.
Yep, that's what I mean, yeah.
No, just I'm taking time. I've read you through the 4th book.
Okay.
I just don't recall seeing one, so I just want to double check because I wasn't looking for it, so. Nope. And I'm on the last one. Go ahead.
Gloss, so you mean not like a dictionary of sorts to kind of help you explain it? Because I see in course materials, they suggested Mosley and Whitley's Law Dictionary. I don't know if that's,
No.
Okay.
no?
Yeah, but I thought you wanted one to go more with the terminologies used in the manual, which would have been good. But
Yeah.
no.
Okay,
Yeah, but
Okay.
that's, thanks for pointing that out. I can also have a look at that. I'm pretty sure that'll help me maybe compile my own glossary.
Mhm.
Yeah, it's just the language you have to get with. You'll get
Oh,
there.
and also there, I think there is a part in here that talks about the different roles. In section, what section is this? What section is it?
Rules.
In unit 2, actually, that breaks down the definition of company shares, company limited by guarantee, hybrid company,
Yeah, we have that in here.
public companies, value-added tax stuff. So
Mhm.
that's another thing.
Yeah, that's why I said when she gets the hard
Okay.
copy, able to make her notes.
Yeah,
Yeah, which would be, I guess, will help you a little bit more. Oh boy, this rain is coming. You know, people like to turn off the light. Famous for that. Even though the bills don't reduce.
listen.
Nope.
As a matter of fact, it was higher. Okay, so let's go to the significance of the Solomon principle in relation to property. So we know that the company is the beneficial owner of its property. It doesn't hold the property as a trustee for the shareholders or the members. And the members have no legal or equitable interest in the property. This is significant because you'll find a lot of people, when they have a company, an operating company, they act as if the assets of the company belongs to them personally. And it doesn't. Shareholders cannot insure the property since they have no legal or equitable interest in the property. So you hear sometimes shareholders say, oh, these are my assets. I own these. No. So notwithstanding the fact that a company is an artificial legal entity, the fact that it can and enters into contractual relationships with other parties and can enforce the contracts which form the basis of their business transactions exposes the companies to both civil and criminal liability. So in the text Company Law by Brenda Hannigan, it says that corporate liability, whether as a matter of criminal or civil law, may be established either, one, by application of specific rules of attribution, whereby the acts of someone else, typically but not necessarily the directors, are attributed to the company. A process which involves the identification of a natural person or persons who are to be regarded as representing the judicial person for the purposes of the substantive rule in question, historically known as the directing mind and will doctrine. So you'll find in company law, whenever there is a legal matter before the courts, the judge will always make a determination as to who is the directing mind and will of the company. That is, who is giving the instructions. Because you could have a person who is named as the manager, but that may not be the person who is giving the instructions. So the court will determine who is the directing mind. Who is that person? Who is the directing will? Who is driving this company? The second thing is, on the basis of wider rules of attribution, namely agency and vicarious liability, where the company accepts responsibility for the wrongful acts of its agents or employees, as in the case with any principal or employer. So remember, when it comes to vicarious liability, that means that an employee who is following the terms of his employment who doesn't act during the course of his employment, then the employer becomes vicariously liable for any incidents or any breaches that occurs. So what are some of those liabilities that a company can be involved in? Contracts. Parties wishing to enforce contracts entered into by companies must ensure that the commitments are within the company's capacity. And the executing officer or agent has the authority to transact such business. So normally what happens is if you're going to go into business with a company and you're entering into a contract, the first thing you need to know or you should ask for is a copy of the resolution. The resolution from the board will tell you, A, that this person is authorized to carry out this transaction. That's the first thing you need to know. Because you could have someone who is transacting a business on behalf of a company who doesn't have the authority to do so. A shareholder cannot enforce a contract made by his company. Same thing, vice versa. A company cannot enforce a contract made by its shareholder. The shareholder is neither a party to the contract and nor is he entitled to any benefit under the contract because all of the benefit goes to the company. A shareholder cannot be sued on contracts made by the company, nor can a court compel a shareholder to vote at a general meeting. That will ensure that the company will fulfill its contractual obligations. Any questions there?
So then this leaves directors liable?
No, it's the company itself. Directors would only be liable if the directors breach a duty. Or if a director did an act outside of their authority.
But so then this makes the shareholders liable?
No, it's the company itself.
Right, so the artificial entity of the company is liable.
Yes. All it's saying is that a shareholder can enforce a contract by his company. So say a company enters into a contract. The shareholder can enforce it. He's not a party to that contract. He's only an.
Oh, so how does that, okay, I'll let you finish.
No, go ahead.
I was gonna say, so then how can, if it's a criminal case, if the company is found, I don't know, breaching some kind of law, how would they then be able to give a verdict on the company without touching the shareholders or directors?
But don't forget now, we just went through that. To touch the shareholders,
They lift
You
the
have-
veil,
you have to pierce the veil.
press the veil, right?
And you- The veil.
Because that would be the only way that they could really convict.
Uh-huh.
Okay,
Now for the directors, the shareholders or the company can sue the directors. And that can only be because of a breach of their duty.
right. Okay,
Okay. Tort. A company can sue in respect of tort committed against it, and it can be sued for torts committed by it. Everybody know what a tort is? Yes?
Is it a wrongful act against another?
Yes.
Person?
Yes. Because remember now, a company, a separate legal entity, it is an artificial being. So all torts committed by a company is done through agents. That's through the directors or the employees. And a company is liable for the acts of the agents if they're acting if they're acting in the course of their employment or within the scope of their authority. And that's why you see a lot of companies have to have insurance because it has to protect itself against such acts. When you have employees who are out there carrying out actions and duties or entering into contracts, you have to have sufficient coverage in the event that the company is sued. So Lord McNaughton in Lloyd versus Grace, quoting from Blackburn J. in McCowan and Dyer, he stated that the general rule that the principal is liable to third person in a civil suit for the fraud, deceit, concealment, misrepresentation, tort, negligence, and other malfeasance or misfeasances and omission of duty of his agent in the course of employment, although the principal did not authorize or justify or participated in or indeed know of such misconduct, or even if he forbade the acts or disapproved of them. But although the principal is thus liable for the torts and negligences of his agent, yet we are to understand the doctrine with its just limitations, that the tort or negligence occurs in the course of the agency. For the principal is not liable for the torts or negligence of his agent in any matters beyond the scope of the agency, unless he has expressly authorized them to be done, or he has subsequently adopted them for his own use and benefit. So this is why when you see persons who are driving a vehicle and let's just say they get in an accident, the first question the employer always asks is whether or not it was done during the course of his employment. So when you left the job, where were you supposed to be going? What were the possible routes you could have taken? Because then the company decides whether or not they are liable or not. Even though the person who was injured in the accident or whose car was hit in the accident will always go after the bigger fish, which is the employer. In these cases, there is a personal liability on the part of the director, for the director's acts are the acts of the company and not his own. However, this is not the case where the director is a joint tortfeasor with the company. So a joint tortfeasor. A director may be liable with the company where he has authorized, directed, or procured the wrongful act. If a director is carrying out the duties entrusted to him by the company under the articles and memorandum, the circumstances for holding him liable as a joint tortfeasor would be infrequent. In the case of MCA Records versus Charlie Records, Lord Justice Chadwick emphasized that the question is whether the individual, that's the director, had been personally involved in the commission of the tort to a sufficient extent. That is, whether the individual will be liable as a joint tortfeasor with the primary infringer, the company that is, whether or not the relationship between the individual and the company was one that individual was a director of the company. And two principles were set out. A director will not be treated as liable with the company as a joint tortfeasor if he does no more than carry out his role as set out in the M&As. And a director will be liable with the company as a joint tortfeasor if he participates or is involved in a wrongful act that goes beyond the exercise of his control set out in the Articles and Memorandum of Association. So the third liability after contract and torts is liability of a director for a tort committed by him. So a director is liable for his own tort, regardless of whether or not he is a director. In the case of Standard Chartered Bank and Pakistan National Shipping, the managing director and the company was sued in deceit. The company was held liable. On appeal, the court ruled that the managing director was not personally liable, as he had made the fraudulent representation on behalf of the company and not personally. The bank appealed to the House of Lords and was successful. Lord Huffman stated that the managing director had made a fraudulent misrepresentation to the bank, and the bank itself relied on it. The law of agency, this representation, and the knowledge was attributed to the company. However, the fact was that the representations and the knowledge were that of the managing director. He was the only human involved in making the representation to the bank. The managing director in this case was being sued not for the company's tort, but for his own tort. He was not liable because he was a director, but because he committed a fraud. A director may also be liable for negligent misstatements if there is an assumption of responsibility and reliance on the assumption. Now, a company can also be subject to criminal law as any other person. Statutory offenses which give rise to vicarious liability on the part of the company as employer for the acts of its employees in the ordinary course of their employment. In some instances, liability may still occur even though the company's management has forbidden its employees to behave in a particular manner. In these instances, the court seeks to determine who is the directing mind and will for the purpose of the liability. So you see, a company, once incorporated, is just like another personality. It's like a human. It can sue and be sued. And of course, for criminal, it goes to who is the directing mind and will? Who is the person given the instructions? Who is the person who authorized? That's the key thing when it comes to dealing with a company. That's why you see certain persons refuse to take certain positions because they don't want to be in that category of directing mind and will. Any comments? I see it's getting dark. No? So we're good?
I have a question brewing in the back of my mind.
Go ahead.
I think I'll wait till you go through it. Because I heard you say that that's why a lot of persons don't like to take the position as a managing director. But I find that a lot of persons who own the business take on that role as managing director. So,
Mhm.
but wouldn't it be, but as long as you follow the, law and as long as you stay within the realms of the role, you should be fine.
Yes. But life isn't always fine, is it?
Yeah, things do happen
To happen.
unintentionally sometimes, you know.
Right.
Yeah, life isn't simple. It's not a bed of roses every, and sometimes decisions made which are not the good ones.
Oh, so you're held liable for decisions, any and all decisions made within the company or for the company on the company's behalf,
Yes,
even if they don't necessarily breach a law.
yes.
Well, that's interesting.
Yeah, don't now. You have in a company, you have the board of directors, and the board of directors then give them the day-to-day management of the company to the
Mhm.
board appoints a managing director.
Right.
And that managing director then takes over the responsibility of running that company. Only thing he actually does is report to the board.
Mm.
And he reports to the board based on the financials, the operations, compliance. What else?
So who would be the safest person? What would be the safest position to take then in your business if you are operate? Because the managing director is essentially the CEO, right?
Yes.
So what would be the safest position if you wanted? I mean, I guess ain't really no safe position, huh?
No.
Unless you're just like a shareholder with minority shares. Who
Yeah,
wants to be that? Okay.
yeah. But I mean, in most companies, if you are the managing director, the head of operations, you're the head of accounting, all of those are senior roles.
But you can protect yourself with professional indemnity insurance?
That would be professional indemnity insurance is carried out by the company itself. And you'll have to make sure that the wording includes all of those positions.
Mm.
So normally when you have someone who is being appointed to the board, the first thing they ask for is to see a copy of that policy, to see what they are covered for in the event that the company is sued, to see what their protection is.
So in the case that the company is sued and there isn't any coverage or that part isn't protected under the policy, then the personal assets of that particular managing director is affected?
Depends on what the matter is.
I mean, in a situation where the company is sued and the director is the one that's responsible for whatever decision was made,
Mm-hmm.
and
So then-
the courts hold the managing director liable. So is that then a situation where personal assets can be held liable?
Mm-hmm.
Sheesh. Okay.
Yep. It really becomes tricky. Yeah, it really becomes tricky. But
So
you got,
then, so
Go
I have
ahead.
a question because there's a specific company that I have in mind, Bahama Divers. I don't know the details of that particular situation, but someone had died under the care of, I guess, a dive master or whomever. And the company was sued and had to shut down. Were any of the parties held personally liable? Do you know?
No,
Or
start-
did
start
it
again.
just,
start again. The shareholder died. Was that shareholder?
no, the shareholder didn't die. A client, a tourist
Oh,
had died. Right. So I'm assuming they probably found that something had gone awry and the company Bahama Divers was held liable. So they were sued and, you know, they lost. So they had to shut down the company. That's why Bahama Divers shut down. Do you know if any of the persons, the shareholders, directors, or anybody were personally held liable, or if the suit just ended at the company being liable? And so they couldn't go beyond whatever assets the company had.
What year this was?
I believe it was right before COVID. So I believe it was in 2018, 2019.
Yeah, I saw that. I came across that. I don't know why. Probably one of my states of insomnia. I believe, because I believe the original owner of that company then opened a new dive company in the Bahamas, if I'm not mistaken. So I suspect it didn't go beyond the assets of the company, and I can't remember the name of the new company, but
That would have been good.
and I think it was a dual jurisdictional
Situation, yeah,
lawsuit,
because
right?
right,
Yeah.
because the person was an American, I believe,
Yeah,
and so they did a lawsuit from there,
9 million.
right, and they couldn't pay it because the
you
company
found
didn't
it?
have-
You found it?
Looking for the lawsuit. I see the write-up in the paper. But I-
Okay.
To
They were
I don't-
sued millions of dollars, and the company didn't have that.
I'm gonna look it up and see, and then I'll send it to you all,
Okay,
and we could discuss it in the next class.
yeah, because as we were talking, I was wondering about that, and I was like, I wonder if the person who would have been, they might not have made a decision in that particular case, that led to the person's death, but was wondering if that had affected the person's responsible, whoever was held responsible, their assets.
Okay, let's see. We'll see what happened. Okay, we'll look that one up and we'll add that to our list for next week. All right. And then if I find the case, I'll send it. I'll look and see. I think Indira Charles did that.
Mhm.
If I can get the case and send it to you all. Bahama Divers, I don't know who's on the other side. Bahama Divers. Indira Charles. Okay, I'll look it up and see how far it went in the courts. Whatever was the last decision. Okay,
Okay, thank you.
Okay.
problem. And that's a good one. So thanks for that. We can
Yeah.
use. All right, so that's it. I need you all to read your cases. I can tell you now, through the week, the days goes very quickly. So try not to wait until Thursday, because when you look, it's Friday and then you wouldn't have read, then you have to rush. And then you can come to class all frustrated. Just giving you a little tip.
Sounds like you've heard these reasons. I'm not gonna call them excuses. Sounds like you've heard these reasons before.
Yes, I have. And I'll tell you what some students like to do too, because they waited to the last minute and they're not ready to present. They don't come.
Oh, Lord.
We
Yeah.
won't do that.
No, what I'm telling you, that's what students normally do. When I say, okay, so who's presenting this? Not here. Next. I say, and who's doing the next one? Not here. Then they come to the next class. Oh, I was running late. I had to do this. Oh, all kind of stories. I
So
say,
on that note, Miss Archer, I'm sorry to interrupt. Let me just say, I was gonna tell you all anyway. I'm actually gonna be at a wedding in Eleuthera, but I plan to plug in anyway next Saturday. And that's only because originally, I think we were told this class was gonna be in September.
okay,
Yeah,
okay.
but I think I have sufficient time because the wedding's not till 4.
You have
Yeah,
sufficient time.
so
Yeah,
I'll be plugging in from beautiful Eleuthera next Saturday, God willing.
yes, and I'll get the incorporators. Those who have some experience in incorporation, for them just to run through that section. So that'll speed things up for you. And then we would look at the differences between the IBC and the company. So you can mold that in your head.
Great. Okay.
So we do the cases first, and then we will go with the different types of companies. We will get any one of the young ladies to do, well, both of them can do it. How do you incorporate a company? And then we would look at the difference between the two. So you can mold that in your head. So if you have the time, you could start to have a look at your IBC Act and your Companies Act to see what's required and to incorporate. But once you,
Question, sorry not to cut you off if you were saying something else.
go ahead.
Okay, so I saw that the Companies Act laid out there, and I was wondering if there were chunks in the Companies Act that you could lift out for the memorandum to put in as the memorandum,
What do you mean chunks?
like sections, not chunks is a probably horrible word to use, but this like sections, and because I haven't read the whole thing, but I
Mhm.
saw it, and I was wondering if there were sections within the Company Act that stipulate the items that are expected to be in the memorandum, or if the memorandum just makes reference to certain subsections from the Companies Act.
The latter.
The latter, okay.
Mhm. But for the articles at the back of the Companies Act, there is a table.
Okay, because I realized too that I guess that's a question for next class,
That's
but I
fine. realized
realized too that through the incorporation process, they give you 2 options to upload a memorandum that would have been prepared by you, I'm assuming, and then there's another option to adopt the memorandum.
Mhm.
So I
That-
was wondering if that's where the adoption of the memorandum came from, that Companies Act.
Mm-hmm.
Okay,
It's at the back. We'll do it next. I'll show you next class.
okay.
I'll show it to you next class. Because a lot of companies don't do it. They don't
What's
adopt,
that? Adopt the memorandum?
they don't.
I realized that because when I did my company incorporation, I had one prepared, like I had prepared one.
Yeah.
I just made reference.
So normally you prepare it if you're going to be making distinctions different from what's in the model articles.
Right.
But if you're not making any distinctions, then you just adopt it. So in a lot of other countries, they don't type up those long articles.
They just adopt, like, for example, the US then, when they
Yeah.
form the LLCs, they just adopt.
They just adopt. Some of the other jurisdictions like ours, Seychelles, they just adopt. Who else? A lot of
Is it because they don't have the option to customize it, or is it just that the current Companies Act is dense and so they need to kind of water it down by adjusting it?
No. When they prepare their own, it's not watered down. They make it more
They make it more,
specific to their operations, how they want the company to run.
okay.
Yeah.
But
But
there
most
are certain,
doing a one-man band, they
uh-huh.
don't, there's no need to be writing all that over and over again. They just adopt it.
If it's a one-man band, do you mean
Yeah.
in the case of an IBC?
But we have IBC, but in other jurisdictions, they're just called a company.
Okay, all right.
So, but I don't know why persons here just don't adopt it. They just like to write out the long thing, and when you read it, in some instances, it's the same.
It's the same as the thing. I think it's because when you go to the Registrar General, they push you to go with a lawyer. They don't advise that, I don't know what they call, regular Bahamians, but they don't advise the general public, yeah. They don't advise the general public to incorporate companies on their own. They want you to go to a lawyer, and a lawyer has they have a template of sorts that they just use for you that doesn't necessarily adopt the memorandum that's in the Companies Act. So it's just, I'm assuming it's just a means to make it more complicated rather than to have people just go and do the first initial incorporation themselves.
And then you could always do an amendment.
Right. So I'm assuming that's what it is. It's a covenant of, never mind. Yeah.
Yeah, I know what you meant. Yeah, because
That's fine.
I asked the same thing myself. Why don't they just adopt it? Because I mean, every time you pick up a file, you have to read all of these long things. But if the majority were based on the standard, I mean, you'll know that off the top of your head. But you have to read on each one. You have to look to see where it's different. So whenever you have a query, you have to read the articles of that entity.
Right.
And silent, then you have to go back to the Companies Act.
Right.
Yeah, it's a lot of work. And then of course you need a lawyer.
Right. You need a lawyer, but you really only need a lawyer to sign off on the statutory declaration.
No, I mean, when there is, when the
You mean when
actual,
it's customized?
yes,
Okay. Yeah.
yeah, then you need a lawyer.
Yeah.
Yeah, so that's what it is. So, I don't know. We'll leave that comment right there.
Yeah.
I'll leave that one right there because that'll get us in trouble, but I agree with you. I agree. All right, so we're good. I think everybody could relax now. It's not that tense. You can read the chapter again and then read your cases, read chapter 2, and then you'll see it's not as difficult as you think it is. Now, are you all up for homework other than reading the cases? Because I like to give questions.
Yes, let's do it.
Okay, all right. So for next class, all a homework question. And I can
Now,
add,
keep in mind, earlier you said you didn't want our brains to explode, so
Oh, hold on, I'm only gonna send you one question after next class,
Okay.
maybe two, just two, maybe two, yeah. And I'll add those points to your midterm,
Okay.
okay? Now, another thing I forgot to say at the beginning of class is that we normally do a capstone. A capstone is like a research paper, not that long. It'll all be based on company law. Something happening in a company, you either a shareholder or a director, and you need to tell me what you're going. That's not due until the day of the final exam. There's no need to worry. But what I like to do is get a feel for the class first, so I know the level at which I will write the capstone. So I don't like it to be too difficult, and I don't like it to be too easy. So I try to find a medium in between. So I'll see how we go after the first 3 classes, and then I'll know just what I'm going to write. So it's not just, may take some time, but it won't be difficult. Okay?
Okay.
All right. So I'll get homework question ready, and I'll get a feel for what I'm gonna write for the midterm. Okay? Ladies, have a great weekend. And
Thank you, and same to you.
enjoy your up and coming wedding celebration in Eleuthera. That's
Thank
nice.
you. Can't wait. Such a beautiful island. I just love it.
Listen, I love Eleuthera. That's my favorite island.
It's beautiful.
That should really be nice.
Mhm.
Oh man, I wish I was going, but I'll be here.
Maybe I'll turn my camera on and just let y'all see the view.
Oh, please don't.
Or not. Then
No.
nobody's gonna want to work.
How you know so well? Everybody, where you going next? So that no, that's okay. You keep it.
Okay, okay.
Keep it. All right. So have a wonderful week.
Okay, thanks, everybody. Y'all
Thank
stay
you.
dry and safe.
Yes.
Same to you.
Be
Same to
ready
you.
to
Enjoy
see y'all on
yourself.
Saturday. Okay,
Yes.
thank you. All right, bye-bye.
Okay.
All
Bye-bye.
right, bye.